Lady Lords, might I just deal with the point that Lord Kerr raised before we broke for lunch relating to disclosure and whether that was ordered by the court and what the procedure is in the Bahamas. There are rules of the Supreme Court out there. The court can order disclosure if the parties want it. It's not clear to us, because we don't have a copy of any order made by the court in this case, whether the local courts made an order for disclosure. It's quite clear, based on the record and the documents we do have, that only selective and partial disclosure was made, albeit that the treating doctors or the experts had access to their notes. I can give you an example, page 158, relating to Dr. Bethel. Volume 1. Line 4, he was asked about the x-rays relating to the neck and whether they'd taken place and whether he'd received the results. And he says sometimes these things are dependent on if the patient followed the advice. So I have to look and see. I can't remember if he actually got the x-ray or if I asked him to get it and he never got it, so I don't recall. I don't see an x-ray report from that time, which rather suggests he may well have had more in his possession than has been disclosed to respondents. And just one other reference, if it assists, Dr. McDowell refers to his notes, which are distinct from his written report at page 191, line 13. So the position is that the board has what we have in terms of the documents which are said to substantiate the appellant's case and no more, effectively. I was just finishing off with the brain injury and Dr. McDowell's evidence in that respect. Just a couple of concluding points in respect of that. It is right to say that the neurological symptoms that were presented to Dr. McDowell and also Dr. Bethel after the alleged assault were very similar to those that were reported to Dr. Bethel. One only needs to cross-reference what was reported to Dr. Bethel in his January examination with his previous reports, and you can do that. You can go to page 746 in volume 2. And this is the police form. And looking at the remarks at the lower part of that form, there's reference to the mental mini-state examination, score 19 out of 30. Dr. Bethel's evidence in that respect was that this is a test that can be faked. So not a huge amount of reliance can be placed, we say, on that. In any event, he goes on to find that there was impairment of abstract thought and impaired insight. Tongue deviates to the left. Well, so far as those matters are concerned, you can look at his report of the 11th of August of 2003, or his letter, rather, of that date, which is at page 725. And you'll see from that letter, second paragraph, that there are references to slow responses on the concentration section, albeit I accept it said that intact abstract thinking was present. You have the tongue deviating to the left-hand side in the penultimate paragraph of that letter of the 11th of August. That's referred to there. It's suggested by Dr. Bethel in his January examination that there's impaired coordination, right more than left. Well, you get that from the accident report form at page 723. Additional injury description. Dr. Bethel examined Jamal, including motor skills and so on. Motor skills in right hand were not the same as left. And then you have reference to difficult visual accommodation. And again, his visual problems are referred to in the letter of the 11th of August 2003. And that's at 725 again. So, and one can adopt the same exercise in respect of Dr. McDowell's written report, which is at 748. You'll see the complaints there are listed under the heading History of Presenting Complaint. He was seen by a private physician on release. He was treated for ongoing complaints of insomnia. Okay, well, there's nothing in the letters to that effect, but that's perhaps a small point. occipital headaches. He'd obviously complained of those before. Speech and memory disturbance, well, there was reference to speech and word-forming difficulties in the previous letters. Memory disturbance, not so much. Generalised spasms, the letter of the 11th of August does refer to, if I take your worships back to that, it does refer in the third paragraph to left eye twitching. Except there's no reference to limb twitching or anything along those lines, but that leads me back to my point made before lunch, which is that the evidence so far as myoclonic jerking was neutral. There was no suggestion that those jerking movements couldn't be faked, except that they were described as subconscious, whatever that might mean. And so it's in those circumstances we say that the judge was entitled to find that there was at least a substantial similarity in the symptoms that were presented prior to the alleged assault with those presented to Dr. Bethel. It said that the judge fell into error at paragraph 73 of his judgment, 77 rather of his judgment, that's in volume 2. Volume 2, page 603, where he said, at paragraph 77, what he says is that he saw Dr. McDowell, he complained of headaches, memory loss, spasm, photophobia, and stammering, reduced range of motion in neck, tenderness of neck muscles, and decreased hearing in the left ear. Every complaint made to Dr. Bell was made from 2002 after the container report. I accept that's not an accurate reflection of his presentation alleged assault. But what the judge went on to say, he clarified that at paragraph 85 of his judgment at page 604, and he simply referred there to the remarkable similarity of the clinical findings of the two alleged incidents, so the container port and the assault. So there's a clarification, if you like, in the judgment in respect of that. But in any event, I do say that the judge was entitled to find that there was this similarity in the presentation, and that called for an explanation on the part of the experts for them to thoroughly examine and analyse the relevance of those pre-existing complaints with what was said to have occurred after the incident. Finally, just on Mr. McDowell's evidence, Dr. McDowell's evidence, there's reference to an audiologist report. You've got that at page 747, volume 2. And this is a report on the evidence that was commissioned by Dr. McDowell, and it was after the assault. And what's said there is simply that Mr. Jamal suffers from hearing loss. It's not suggested that that hearing loss was down to blunt force trauma. It's not suggested that this was consistent with the allegations of assault. There's no baseline reading so far as his hearing is concerned, in the sense that you don't have an analysis of what his hearing was like before the alleged assault, and you don't have an analysis of what his hearing was like when he was initially complaining of neurological symptoms as far ago as 2002 and 2003. So the evidence is limited so far as the relevance of the hearing loss is concerned. McDowell did say that this is consistent with blunt force trauma, but how he could say that, we don't know, in the absence of that form of baseline evaluation. So the audiology report just doesn't take matters further at all. And what that leaves the court with, so far as brain injury is concerned, is a presumed diagnosis of a petrocell fracture, of which there is no evidence on the MRI scans or the CT scan, and a hypoxic injury, which is also presumed and not fully explained by reference to the EEG. That's effectively the nature of the evidence that was presented in respect to the brain injury. And Dr. Bethel's evidence didn't take matters further either. Just one final point, if I may, relating to Dr. Harris. Her evidence wasn't of any real utility so far as diagnosis was concerned. but her reports are at page 727 onwards, or rather her selected correspondence is at page 727 onwards. And you'll see at 727 a copy of her letter to the Human Resources Department. She worked for Mr. Cleare's former employer. And their second paragraph, she refers to fainting episodes and massive headaches being complained of. She says that he was seen by Dr. Bethel and an MRI was ordered. Well, we don't know anything about that, but she goes on to say it apparently showed a bruising on the brain. Actual report not yet available to me. He's placed on neurobiology part 1, neurobiology part 2. Those are vitamins. And then there are complaints of dizziness, headaches, and fainting episodes at least 3 times a week. And over the page, penultimate paragraph, page 728, what she recommends is this, a follow-up MRI scan of the brain as well as a thorough workup by a neurologist. So certainly by that stage, he was still complaining of long-standing neurological difficulties, and she put him on Topamax for his headaches and the like. Just finally, at 729, second paragraph, in September 2005, he's been referred to Dr. Raming. We don't know who he is, but it seems to have been for neurological testing and evaluation. We don't know what the outcome of that was. And thereafter, yes, it's right, Dr. Harris considers his symptoms have improved and therefore he's fine to go back to work. But that was from the perspective of a doctor who was working for his company. The impetus, or her main goal, obviously, is to have him return to work. That's the evidence in respect of brain. Very briefly, in respect of the neck injury, the points are these. One, the neck injury isn't identified in Dr. Bethel's examination of January 2007. It's not referred to at all in his diagnosis. He only refers to a diagnosis of a hypoxic injury. And one would have thought if he complains of an assault at that stage, and had he suffered a fractured neck, it might have been at least picked up by Dr. Bethel at that stage. Second point is, it's clear that he had pre-existing problems with his neck, and you get that from Dr. Bethel's letter of the 11th of August 2003. It's clear he had orthopedic treatment in respect of that neck problem, and it's clear that x-rays were done, although those weren't made available to the defendant. And by reason of the fact the x-rays weren't available, we simply can't say whether he had, in fact, fractured his neck at an earlier stage. The position is left open. Effectively, we don't know what the imagery would have showed. Now, it's right that Dr. McDowell does subsequently diagnose a fracture of the neck. He says in his evidence that there is the presence of inflammation, and he says that he can therefore time the break or the re-break or the new break to a period of 2 to 4 weeks, but he doesn't say how or why. He simply says, well, there's inflammation and therefore this is a new break. The position, we say, is not thoroughly analysed in the evidence.
But if he's not challenged on that?
No, I accept that.
Yeah. What alternative does the judge have?
Well, what's left in terms of the neck injury is a diagnosis of a fracture and a suggestion that the fracture is a recent one. But what's not said is that this is due to the assault. It might be, it might not be. It could have been down to some other accident that's unknown to us. It could have been down to the Miller self-infliction.
Yes, as to the cause of the injury, I can quite understand Dr. McDowell's evidence doesn't speak authoritatively to that. But if the judge is addressing the question, did he suffer from a break or a refracture, and does that date from 2 to 3 weeks before? Isolating it that way, given the evidence, unchallenged evidence of Dr. McDowell, would he not be bound to say that he probably did?
My suspicion, no, because where you have credibility at the heart of a case, where you have the honesty of the appellant's account at stake.
No, but that's why I left out the question to you, whether or not it had occurred in the way that it did. I mean, if Dr. McDowell says, well, I don't know what caused the fracture, but I do know that he has either suffered a fresh fracture or a refracture, and it dates from 2 to 3 weeks ago. I mean, is the judge, in the absence of any challenge or contrary evidence, does he have any alternative but to accept that that is correct?
My Lord, he's certainly got to consider the evidence, and he's got to weigh that along with all of the other evidence, both for and against the fact that the assault has taken place. It is simply one part of the evidence that the judge has to consider. And yes, of course, he absolutely does have to consider it, but it's not determinative. My point is it's not determinative of the fact of an assault. It might be consistent with an assault.
I fully accept that.
Yes, it might be consistent with an assault, but it's not proof of an assault. That's our point. And I'll come on to take you to the judge's reasoning. So those are the short points, effectively, in respect of the neck injury. We say it only goes so far; it's not determinative of the issue. And so it is sensible to have a look at how the judge approached all of these matters in his judgment. And you have his analysis of the evidence, the medical evidence, at paragraph 69, page 599, volume 2. And I'll just take you through the highlights, if I may. Paragraphs 68 and 69 are simply background. They just deal with the complaints and the police complaint in particular. It really begins at paragraph 70, or the judge's reasoning begins at paragraph 70. The point made at paragraph 70 is the point that I've already made, which is that there was no complaint of suffocation made to the police at the time, and that was consistent with the contents of the police report form. So the judge was entitled to take that into account. And then what you have at 73 is the point that was made, that was discussed, I think, by Lord Wilson earlier this morning. Just why did the doctor think to make the unsolicited remark that the change is very unlikely to be fake? Well, we support that reasoning. Why would he say that? And I've taken you to the passages which show that Dr. Bethel did, in fact, have concerns about the appellant's veracity. So again, that's a relevant factor that this judge, we say, was entitled to take into account. And then at 74 through to 77, you have a summary, if you like, of the pre-existing complaints that I've already taken the balls to, and in particular, reliance is placed on the letter of the 11th of August. And the point that's being made by the judge, effectively, is that there is no explanation or no rationalisation of those pre-existing complaints with the evidence as presented to the court. There is no real consideration given by either Dr. McDowell or to Dr. Bethel as to the relevance of those previous complaints and the impact that has on their conclusions. And he's entitled to make complaint about those in his judgment. I've dealt with the point about every complaint being made to Dr. McDowell was the same. As I said, he goes on to simply refer to there being a remarkable similarity, which there was. And then at 78, he tries to pin down what the nature of the complaints were, and this deals with the idea that the hypoxia injury was presumed. So he goes through the injuries as particularised in the pleading. He notes that the word presumed was omitted from the pleaded case, and that that omission changed the meaning of the claim effectively. Because all this medical evidence did on a proper reading is show that there was a presumption of an injury, not an actual injury. And certainly didn't go as far as to say that this was down to an assault. And he's entitled to rationalise the evidence on that basis, we say, if you accept our analysis of the medical evidence. he narrows down the complaints at 79. They come down to concussion, hearing loss, neck injury, and hypoxic insult. That's fine. He notes the conflict between Bethel and McDowell with regards to the CT scan at paragraph 80. And again, there's no getting away from it. There is a conflict between Dr. Bethel's diagnosis and Dr. McDowell's diagnosis in respect of hypoxia. And then these are perhaps the most important paragraphs so far as the brain injury is concerned. Paragraphs 81, he sets out there his understanding of the medical evidence. The finding that there was brain damage or a hypoxic injury or hypoxic insult injury was based on a clinical finding made by both doctors. That, for example, the tongue deviated to the left, there was sensitivity to light, stammering, myoclonic jerks, impaired memory and word finding difficulty, and MMSE results. That is why in his report, Dr. McDowell used the word presumed to describe the hypoxic insult. Plaintiff left that word out when particularising injuries. That was misleading. It was the clinical findings that raised the presumption of a hypoxic insult. Now, I accept that there's no reference there to the EEG. But what the judge is getting at here is he's referring to the written report of Dr. McDowell, which refers to the presumption, which refers to there being a presumed hypoxic insult and hypoxic, beg your pardon, which refers to a presumed petrocell fracture and a hypoxic insult. So his reading of Dr. McDowell's evidence is that this is all presumed. And that's right on a proper reading of that evidence. So we say there's no material error here. And then at 82, Mr. Tynes argued, as the transcript appears to disclose in cross-examination and re-examination of Dr. McDowell, that he in fact saw tissue damage to the brain. This is the point made and repeated before this board, that led to his opinion of hypoxic injury. However, nowhere in his report of the MRI of the brain, as opposed to the MRI of the neck, does the doctor say he saw actual damage to the tissue of the brain. And had he done so, he couldn't have said, in my judgment, that the MRI of the brain was normal. So he's right in this sense. There's nothing on the MRI and there's nothing on the CT. Judge should have referred to the gliosis point and he should have rationalised it, but it doesn't matter anyway because the gliosis doesn't establish, even on a proper reading of McDowell's evidence, a brain injury, only a presumption. So there's no injustice done. Paris, just to pause at 82, he does refer there to the neck injury, so he's got it in mind. And he does accept that it shows an injury and it shows actual damage. And that goes back to my point that the neck injury is something that he can weigh in the balance along with all of the other evidence, but it's not determinative. And he's entitled to reach that finding, we say. He's then, at paragraph 83, critical of Dr. McDowell because he hasn't got the medical history, and in that, and what he's getting at there is he hadn't had sight of Dr. Bethel's letter of the 11th of August, and that was plainly pertinent to his conclusions. 84 relates to 84 and 85 relate to the container port, so that goes back to the similarity. And 86 does as well. He refers to those findings mirroring the presentation post-alleged assault. He refers he refers to similarity in the injury to the neck, again at 86, C2 level, with the area of the spine after the alleged accident, and he's right to do so. There plainly is a similarity, or at least the evidence is not explained by reason of the absence of the X-rays. And therefore he reaches his conclusion at 87, that the medical evidence simply isn't as cogent or supportive as the appellant contends. And we agree with that. It's plainly a matter of weight. He hasn't said, I've already disbelieved him, so none of this matters. This is a careful balancing, we say, of the medical evidence against all of the other evidence. So he's carried out the necessary balancing exercise. He's carried out all of the analysis that's necessary on this case. And at the end of the day, it's a straightforward case. It's a straightforward race to whoever has the most credibility. And the judge was entitled to find that the defendant's officers were more credible than the appellant's account was. The Court of Appeal simply repeat those findings. So their consideration of that evidence, just for your references at paragraphs 12 to 18, volume 2, page 643. I don't need to take up the board's time with that. So we say, just in summary, there's been no material misunderstanding of Dr. McDowell's evidence so far as the trial judge is concerned. EEG doesn't support appellant's injuries. It's not conclusive evidence of anything, really. All the evidence goes to is a presumption that there's been a fracture of the brain. It's not shown up on any of the scans. The jerking and memory loss don't swing the balance in the appellant's favour. There was evidence of some sort of twitching that pre-existed the assault. The memory loss was only confirmed by a single cursory test. McDowell's evidence in respect of timing, it was only subject to limited analysis on his part and not self-proving. Judge entitled to take into account the overlap in symptoms between pre-assault and post-assault. Entitled, therefore, to find that McDowell's evidence was not as reliable as presented by the appellants. What this left was effectively Miller's evidence that the appellant had, in fact, self-inflicted or sought to self-inflict a head injury under the guise of, and with the aim of fabricating a claim for assault against the police, and also the appellant's ex-girlfriend's evidence that, in fact, he didn't stutter after the alleged assault as much as he presented with at trial. And those are all key features and factors that the judge was entitled to have regard to. I'm conscious of the time I had till... Well,
you've just about run out of time.
Yes.
But it seemed to me you've also possibly run out of things to say.
Yeah, I'm grateful.
That's no disrespect to what you have said.
The only other point was the point that I raised at the outset, which is that the points relating to conduct of trial, so the site visit, the absence of the original detention record, the absence of the witness statement taken by Dr. Ryan, they're all dealt with in our written case at paragraphs 83 to 88. I don't need to trouble you with them, unless I can insist any further.
Thank you very much indeed, Mr. Ruttwell. Ms. Deal.
Thank you, my lady. If I could start with the points that I said in my original submissions that I would come back to. The first mention that was made of the plastic bag, the second one, that I thought was the first one, was the one that was made to Dr. McDowell on the 2nd of February. In fact, at page 166, this is from the evidence of Dr. Bethel, who saw the appellant on the 25th of January. At line 10, or you say go up to line 6, Jamal Cleare said the people that attacked him in the cell, he presumed were police officers. Well, there were two incidents. Question, please tell us. One, he was taken into custody, and there was an incident with a bag. I believe that happened outside of the jail, outside the jailhouse. He reported he was accosted by people in the cell. So it's not absolutely on all fours with the version of events that ran through to trial. But in my submission, it is clear from that on the same day that the appellant went to report his complaint to the police complaints, he also told Dr. Bethel that there had been an incident with a bag. That, of course, then became that much clearer by the 2nd of February when he went to see Dr. McDowell. The second point that I said that I would come back to with the references, although I suspect that your Lordship and Lordships have already noted them, thanks to my learned friend's helpful analysis, was regarding the similarity of the complaints and what the trial judge said about that and what the Court of Appeal said about that. The references that I would invite you to take into account for the trial judge are paragraphs 77 and 86 of his judgment, and for the Court of Appeal, paragraphs 25 and 37. Coming back to the question of the similarity of the complaints themselves and picking up the points that my learned friend has just raised. (725) is the report from Dr. Bethel from August 2003. That is the best evidence, some evidence, in relation to the complaints that the appellant was making following the container port incident. He reported in the middle of that page that his left eye was twitching on June the 18th, 2002. That is not a complaint that is then referred to on any, at any subsequent that Dr. Bethel makes. And his conclusion, as you can see over the page, is that, leave aside the headaches and the dizziness, which he doesn't think are caused by head trauma, he thinks that these symptoms are most likely related to a problem of eyesight with migraine headaches. So he's complained of an eye twitch, and the diagnosis at that stage is that he has a problem with his eyes and migraines. He also reports that the claimant, or the appellant I should call him, is suffering from headaches, throbbing headaches, worse with bright lights and loud noises, again said to be consistent with a migraine-type headache. And of course he identifies that the appellant was referred for x-rays of the neck showing loss of normal lordotic curve and impingement at the C2 vertebra because he's complaining of problems in the area of C2. By the time he sees Dr. McDowell, page 749 is what is being noted by the doctor at that stage. Extraocular motions normal, pupils symmetrical, visual acuity normal in both eyes without correction, no visual field abnormality, had midline tenderness in the neck, bilateral trapezius spasm, decreased range of motion. Motor examination showed a tendency to myoclonic jerks. I've already made reference to that and the explanation that Dr. McDowell gives about those being subconscious, with no detectable weakness in any of the major muscle groups. Had no fasciculations seen. Now, I'm afraid that was not a word with which I was familiar, but it is small muscle contractions. So, as far as Dr. McDowell, who of course is a neurosurgeon, is concerned, there are myoclonic jerks that he is noting, but there are not twitches. There are not the small muscle contractions. He is drawing the distinction between myoclonic jerks and fasciculations. In my submission, my learned friend cannot make good the argument that because the appellant complained of his left eye twitching in June 2002, that you ought to assume that that is really part and parcel of the same constellation of problems that he was reporting to Dr. McDowell, which Dr. McDowell was identifying as myoclonic jerks. If the point had wished to be made that a myoclonic jerk either is not a subconscious movement or that it can be faked or that something that is conscious can be misunderstood as being subconscious, then Dr. McDowell was there to be questioned on it, and of course he wasn't. The other symptoms that have been complained of, say there's the spasms in the neck at C2 level. And I can't get away from that, and I don't need to. That was what he was complaining of when he saw Dr. McDowell, and Dr. McDowell took the initiative and arranged for the MRI, which showed, courtesy of the inflammation of the tissues, that there was either a new or a fresh fracture there. It matters not in my submission that the appellant may have had pain in his neck in 2002, pain which, of course, had abated by March of 2003. Because what we do have by the time he goes to see Dr. McDowell is something that happened between 2 and 4 weeks previously. The similarity of complaint, similarity of presentation in relation to the neck pain does not get over the timing of the damage. And of course, it's the timing of the damage that was of critical importance and that ought to have been factored into the trial judge's assessment. Reference was made by my own friend to there being suggestions of the Basel skull fracture in 2002. The only point that I would make on that is that at 2:10, Dr. McDowell was asked about that and confirmed that, of course, that is something separate from a fracture of the odontoid bone, a fraction of the C2 vertebra. And much was made about the fact that Dr. McDowell didn't see this medical report summary that we can see at 725 and 726. And much was made of that, essentially, because that is one of the main reasons on which the trial judge said that McDowell's evidence had very little value. But I must mention that simply isn't a sound conclusion that can be drawn from this, because what happened, I've already taken the reference, was that very, very quickly into his cross-examination, Dr. McDowell, having said, yes, I did have his history, is taken to this report. And bits of it are read out to him. And this is at the bottom of 202. Jamal returns to say the throbbing headaches had returned, was worse with bright lights and loud noises, and this was consistent with migraine-type headache. His physical exam was noteworthy of tenderness at the C2 level of his neck, with left side trapezius muscle spasm. Answer, that is what it says. You had indicated that when Jamal Cleare came to see on the 2nd of February, he complained of headaches. Right. Memory loss, spasms, and photophobia? Yeah. Could you explain if there's a difference between what you would have seen and the report where he said there was sensitivity to light? As far as I know, no. So the passage of this report of Dr. Bethel that is regarded as being sufficiently important that it has to be brought to Dr. McDowell's attention during the course of his cross-examination is the reference to the throbbing headaches, the sensitivity to the bright lights, consistent with migraine, and tenderness at the C2 level of his neck. But if one goes just slightly up that page, you can see that McDowell has been asked whether he had knowledge of the headaches. Yes. Do you have knowledge of being struck in the head? Yes. Did you have knowledge that he had sensitivity to light and blurred vision? Yes. So Dr. McDowell has identified that he was aware, without having seen this letter of the 11th of August 2003, exactly those parts of that letter to which his attention was then drawn. It is quite right that he wasn't asked in terms, of course, of cross-examination or indeed in re-examination, whether this letter of August 2003 caused him to change his professional opinion. As mentioned, there was absolutely no need for him to be asked that by anyone, because it's quite apparent that it didn't cause him to alter his professional opinion, because the things that are being highlighted for his attention are things that he was aware of anyway. If one looks at that letter as evidence of that which the appellant was complaining in 2003, it must mention it simply doesn't bear the conclusion that there was really any similarity, let alone marked or extreme similarity, between the complaints that Mr. Cleare was making in 2002 and 2003 and the complaints that he was making in 2007. The similarities essentially come down to pain in the C2 area, headaches. When he stuck his tongue out, it's deviated over to the left. Very little more than that. compared to the problems that Dr. McDowell identified, which were marked and significant and, importantly, improving over exactly the time scale that he expected them to be improving, then in my submission one simply can't look at this letter and describe the importance to it that my learned friend, or indeed the trial judge, have attempted to do. Finally, dealing with this question of the hypoxic injury. We don't rely on Dr. Bethel and what he saw on the CT scan as proving that the appellant suffered a hypoxic injury. In fact, we say he was right, he had suffered a hypoxic injury, but we're not putting Dr. Bethel, a GP and an anti-aging specialist, forward as somebody that was able to identify damage on the CT scan that Dr. McDowell was not. Hypoxic injury, in my submission, is the mechanism of injury. It's the means by which somebody has sustained injury, because it is the deprivation of oxygen. You're not going to sustain, as Dr. McDowell explained, a hypoxic injury by hitting your head unless you then go on and fall face first into a puddle. It is not a symptom in its own right. It's not like a broken leg that can be seen and identified on an X-ray. What it is a diagnosis that is reached by Dr. McDowell on the basis of what was available, in which he highlights at the bottom of page 194, as being the EEG, the clinical findings, which of course included the myoclonic jerks, and knowing how the injury was said to have been sustained. So if you hit your head, you're not going to suffer a hypoxic injury. And that is why, for him, it was a presumed hypoxic injury, because it is part of the evaluation of all of the information that is available to him as a doctor in order to identify how has this person come to be injured. And that was not something, in my submission, that was open to the trial judge to dismiss out of hand because he disbelieved the appellant. An expert drew the conclusion that there was a hypoxic injury, an injury sustained by the deprivation of oxygen. One has to be very careful to ignore that or say that it's wrong, at least, of course, without very careful consideration. And when that's set against the absence, we say, of really any other plausible explanation for this constellation of symptoms that was seen by Dr. Bethel, improving by the time that the appellant is seen by Dr. McDowell, improving over the period that he's being examined by Dr. McDowell. Now it's clear, as in my submission it must be, that those are not symptoms that are dating back to the container port incident. There was, for the trial judge, left only one possible explanation, and that was the explanation that the appellant gave. Is there any further questions? Those are my submissions.
I think not. Thank you very much indeed, Ms. Beale. Grateful to you all for your submissions, both orally and in writing, and we will take time, hopefully not too much time, to consider what advice we will humbly offer to Her Majesty. The board will now adjourn.